Hi there everyone, good evening and welcome to The Money Show. This is the real estate special and our phone lines will be open over the next half hour. So if you have any questions or queries, please feel free to dial in. Over the next half hour, we'll be talking about various topics as well as answering all your questions. Joining in today on the show to guide us, we have with us Parizad Sirwalla, Partner and Head Global Mobility Services Tax at KPMG. Parizad, lovely to have you with us on the show. We have a whole host of questions and queries lined up, but let's start off with the first topic, talking about house property and the curbs on set-off of loss. Can you just spell out what exactly is applicable and what this means?
Sure. From last year, which is to be precise, tax year 17-18, what used to happen was that for rented properties or properties, if any individual had more than one house property, which was not self-occupied, which was on mortgage, and if, of course, there was a loan interest, which was a permissible deduction, so that would be allowed as a permissible carry forward without any restrictions. And you could offset that against, even during the same tax year, against your other income, say as an example like salary income. So your net taxable income would reduce to that extent. But with effect from the year 17-18, the budget had amended this provision. So for self-occupied property anyways, which is on mortgage, the threshold limit for the interest deduction was 2 lakhs. But for any other property which was not self-occupied, now there is a maximum cap of 2 lakhs only. So what that translates into is that, you really cannot use the incremental interest burden that you may be paying. So which means your loss from house property is restricted to 2 lakhs. So in that sense, from 17-18, some of the people who had home loans and, either more than one house property or rented or deemed to be let out, they are possibly facing a higher tax outgo on account of this change.
Right, that's the view coming in on the change and what the implications are. Do remember, our phone lines are open. If you have questions or queries, you can either email us on The Money Show at etnow.tv or dial in live. Well, we've got an email question from Rupesh. He says, I booked a property in October 2013 and now it's ready for possession. I have partly funded the property and the rest is financed. It is not registered in my name yet, but I already have someone interested in buying the property. I want to know the tax implications and also how do I calculate the post-tax returns? Will the capital proceeds be exempt if they are reinvested in a property after I sell the one I have? From a tax perspective, is there a better timeline to sell? So he's packed in a lot of questions in this query. Let's start off by talking about the tax implications, given that it's not currently, it's not registered in his name, and to talk about from a tax perspective as well, whether there's a better timeline to sell, he asks.
Yeah, so in these days, particularly in the city of Mumbai or anywhere in India, if you see the kind of real estate arrangements that are prevailing, there are multiple and varied, agreements being entered, whether it's redevelopment of property, soft launches of builders. So there are various dates in a real estate transaction that we've generally seen due to the nature of the industry as well. Now, there are a couple of factors in this question, and as you rightly said, there are many questions packed in this. I'll just outline what are the key factors that one needs to take into account. What is the asset being sold? Are we selling a fully ready property that is already constructed and you may or may not have taken the possession? Or are we selling something which is a right to a property? So a number of factors and parameters of each case have to be examined. Generally, court cases have, and there are also conflicting judicial precedents on this. Some of the key factors that tax case laws have analyzed is date of acquisition. Is it, the date when you register the agreement? Is it the date when you fully paid off or paid off the majority of the installments towards your house? or is it the date of registration of the property, or is it the date of possession of the property? As I said, with multiple scenarios, there are no easy answers. Generally, courts are inclined to take a view that the date of possession is, what should be considered as the date of acquisition, but there are no easy answers out here, as I said. Merely because your registration is not done, but if you have an unfettered right to receive the asset and the property is ready, could also tantamount to the date of acquisition. Now, why is it so relevant? For something to be classified as long-term or short-term. So, for instance, if it's a fully ready property out here, and it will be long-term capital gains only if you held it for a period of 2 years or more. But if it is not really a flat or a property and it's only a mere right to receive an asset, that's also a capital asset. Then the period of holding to classify as long-term could be different, which is 3 years in this case. And therefore, the consequential capital gains provisions follows. The exemption part, which is the rollover relief, generally comes into play if it's a long-term capital gain. So therefore, it is important to understand again, based on the actual fact pattern, what is being sold. Assuming in this case the fully property is being sold, period of holding would be 2 years. If sold after 2 years, the person should be able to get reliefs, and there are specified provisions. If you invest, if you are selling a house and you're investing in a new house, then you can invest the capital gains within prescribed timelines and accordingly get the exemption. But again, a word of caution out here, with multiple housing arrangements, it's very important. It's not such straitjacketed answers that you can get. Facts have to be examined in great detail.
That's the tax angle when it comes to the sale of the house. I hope, Rupesh, we were able to answer your question. Parizad gave you a very detailed response to all of the sub-questions as well that you had. Do remember, if you need any more clarity, you can dial in or email us on themoneyshow@etnow.tv. For now, let's move on to our next question, a relevant one as well. So, hope you're all ears. Rajesh Vyas, by the way, has sent it in to us. He says, does the transfer of rights, title and interest in a plot come under section 50C and 56(2) of the Income Tax Act? So, let's talk about the transfer of rights, title and interest of a plot. What section under the Income Tax Act is it under?
So first, one needs to understand the objective of these sections. Section 50C that you mentioned is basically qua the seller of an asset, the seller of a property, and the wordings under section 50C is only for land and building. Section 56 is vis-a-vis a recipient. So in a property transaction, it is vis-a-vis the buyer of the property. So 50C is relevant for the seller, 56 is relevant for the buyer. Now, what exactly are these sections talking of? 50C says that, if there is the difference between, so what happens is sometimes the sale agreement is even lower than your stamp duty valuation. So, if the difference between the sales consideration and the stamp duty valuation is greater than 5%, the law stipulates that your sale consideration for the seller for the purpose of calculating capital gains tax in his hands is enhanced to that extent. So as an example, if the stamp duty valuation is 55 lakhs as an example and the sale agreement is for 52 lakhs, 3 lakhs gets added as sales consideration in the hands of the seller. So basically his capital gains are enhanced to that extent, because again you have different times, sometimes arrangements of capital gains where the agreement is shown at a lesser value. So 50C is qua the seller of the property and it says land and building. It does not really specify whether a right to a land or a plot is covered there or not, but largely it's from a seller's perspective. 56 again is from a buyer's perspective, more or less with the same objective, which covers anything, receipt of money, receipt of property. Again, in this example, if a buyer is receiving a property In this example again, 3 lakhs can also be taxed in the hands of the buyer. So to this extent, there can be double taxation, but the objective of these two sections is that, the stamp duty valuation plays a role in ascertaining what is the correct sale value. So for the seller, it's enhanced capital gains. For the buyer, well, he's received a higher value property, if at all, for a lesser value, then equivalent is tax in his hands also as income from other sources. That's how both these sections operate.
All right, that's the take coming in. Tax on immovable property. Both the sections have been spelt out in great detail, and Parizad has given you the view as to what is applicable. Well, another topic then, Parizad, before we focus in on a lot more viewer questions and queries, let's talk about the tax benefits on home loan. How does one differentiate between long-term capital gains and short-term capital gains, and give us a view as to what exactly is applicable?
So, sorry, Aman, what has it got to do with home loans? So, long-term capital gains and short-term capital gains, there are separate rates of taxation, there are separate periods of holding. Generally, if an asset is held, depending on the nature of the asset, for 2 to 3 years, it can qualify as long-term, else it's short-term. And largely for long-term capital assets, if sold, there are certain exemption provisions coded in the law. Short-term capital assets generally don't have any exemptions, even if you invest it in bonds or other house property. And of course, the rates of tax are different. Short-term is treated like any other income. So if you're taxed in the highest bracket, then the peak rate will apply to you. Long-term can have concessional rates of taxation depending on the asset that you're selling. I thought your question was also on home loan, which we covered that, principal repayment of any housing loan is covered under your bundle ATC limit of 1,50,000, which has a host of other expenses and investment avenues as well. And, mortgage interest is something that we already spoke about a little while ago, where it's now capped at 2 lakhs, for all kinds of properties.
That's the take coming in. Let's connect with our first live caller. We have Anmol, who is joining in on the phone line with a query for Parizad. Anmol, can you hear me? Good evening. What's your question?
Yeah, hi, good evening. Thank you very much for taking time, Parizad. My query is very simple, So the thing is, I had purchased a house in Mira Road, and the thing is, I was unable to pay the loan for that, and my brother-in-law ended up depositing money in my account, and I am so he's basically helping me pay for the house.
Okay.
My question is that how do I transfer the house in his name? I mean, so can I gift deed him after the entire loan amount finishes, or how do I transfer it into my brother-in-law's name? Is it even taxable? That's my query.
Parizad?
Yeah, so, if I've got the question correct, then first of all, who's the owner of the property? Generally, the owner of the property is the one who's funding it, okay? In this case, merely by having an agreement in your name, if you're not funding it, then there could be doubts as to whose asset it belongs to. How you transfer the property is something that you will have to see under also the Transfer of Property Act, the society rules. I don't know whether it's a ready property, and maybe you need to consult a real estate lawyer to get the transfer deed done. You mentioned brother-in-law, so there are certain, one needs to also check further that if you're really gifting this to him, but in this case you said it's, he's paid, so effectively he's the owner of the property and the asset is his. But if you're gifting something to a relative, and relatives are defined under 56 of the Act, then, per se gifting of an asset to a relative is not covered. One needs to really check whether brother-in-law is covered under that. But other than that, I think the moot point out here is who's funded the property and to what extent.
Funded the
Transfer is merely outside, I mean, yeah.
Okay, that seems to be fairly crucial. I hope we were able to answer your question, Parizad. Would have loved to chat more. But I believe we have to. Okay. Okay, let's just continue. Parizad, were you continuing with your response?
Sorry, I'm not able to hear you well. Can you please repeat?
I'm saying, would you like to add on to that response to Anmol?
No, I'm done with
it.
I'm
great.
done with it.
So that's the take coming in. I hope we were able to answer your question. Let's take on board another query, and this is emailed to us from Nandita. She asks, how are commercial lease structures different from residential ones, as I am looking to invest in a commercial real estate property. This is in North Mumbai. So what are the factors that I need to keep in mind? Parizad, I'm sure a lot of people will be curious about this. Can you just highlight for us what are some of the key differences, and when it comes to investing, are there any particular points that one needs to keep in mind?
So first of all, I'm presuming the person is investing not in the course of business and profession, more as an investor. So not many differences, I would say, except that, unlike what we have in residential properties where, the classification is self-occupied or otherwise, and where the provisions could be different, in commercial there is nothing obviously like self-occupied. If it is rented, then the same is taxed as rental income, as income from house property. All losses from house property, whether commercial or otherwise, are capped at 2 lakhs, as I said before. The other key difference would be that, if it's taken on a loan, then the principal repayment of the loan, which is available in ATC for a residential property, is not allowed for a commercial property. So barring this, there are no major differences except these 1 or 2 that we've said.
All right, Parizad, we'll let you go on that note. Thank you so much for taking time out and answering all of our questions and queries from our viewers. Look forward to having you on more often.